Good evening, everybody. Welcome back to our lecture series on the topic of compensation that we have covered so far in two lectures. Section 73, which talks about general and special damages, the first part of it. And in the second leg of the lecture, we spoke about the remoteness of the damages as well as the measure of damages. So if you have not covered these topics, you can go and watch my videos from YouTube. Now, in today's class, we will be moving ahead and we'll be talking about a very important concept, that is, firstly, what is penalty and what are liquidated damages. Okay, if you have access to your Indian Contract Act, Ware Act, please refer to it. You will find when you browse that section 73 or 74 does not per se use the term liquidated or unliquidated damages. Then how are we saying that section 74 is based on the concept of liquidated damages? This is the first thing that we'll try to find out. Secondly, what are penalty? We all have heard of Indian Penal Code. Now, why is it called Indian Penal Code? So let me just share my screen with you and we can write here and we can understand the topic from here. So I hope the topic is visible to all of you. Penalty and liquidated damages, a study of section 74 of the Indian Contract Act. Okay. Now, as I just said, we are talking about the term penalty. And why this term penalty, ma'am? If we go back to our Indian Penal Code classes, you can recall and you can understand that we use the term penal because the intent there is to punish the wrongdoer, which is not so there when we talk about Indian Contract Act, because this is a civil law. We tend to give compensation, and just in the beginning of the class we spoke about compensation and damages. So why penalty has been mentioned here? And even if that we have used the term penalty, how has the judiciary construed this is what we are going to understand. Okay, so these are the two topics that we are going to cover, which is mentioned under section 74 itself. Before I move ahead with reading of section 74, I will just give you two examples. Now, the idea of introducing example in the beginning of the class, if you refer to my last video from section 73 itself, I gave you an example in the beginning of the class of chia seeds. Okay, that is only and only for you to remember these example and the concept behind it. So you do not really have to cram up and mug up if you understand the concept. So let's divide two illustrations in our head and try to find out that which one is penalty or which can be classified and understood as liquidated damages from this example per se. Okay. So the first example is that there is a manufacturer. The manufacturer has entered into a contract with a dealer. Okay. And he has told the dealer, listen, I am giving you the tires and tubes, whichever I have manufactured. But with this, I am also providing you a list of price. So your products, when you try to sell my tires to somebody else, you have to stick to the price that I have given to you in the list. Okay. Now, in this agreement, there is one more clause that they have mentioned, and that is, in case you fail to follow or to practice this, and in case you try to sell away the tire at a higher or at a lower price, you will have to pay me what? A penalty or an amount of money which is £5 per breach. So every time you do not follow the condition that we have told you, you'll be held liable to pay me this particular £5 per transaction. Okay, so this is the first case wherein we have to find out whether this can be understood as unliquidated damages or it can be considered as a penalty. Okay, what is the primary concept or primary idea of penalty in your mind? As I said, penalty is something where the intention is to punish a person. Okay, like what is the punishment given under IPC and now called as BNS? What is that? The punishment is wherein you see there is fine. We do not say compensation there. We very specifically use the term fine. We say imprisonment, rigorous, simple. We talk about death penalty. We talk about life imprisonment, forfeiture of property. All these sound as that they are punishing somebody for the wrongful act. Now, in keeping that concept in mind, try to understand my next example. Okay, X is again a dealer. or a manufacturer who enters into a contract with Y, the dealer, and he tells him, I am giving you parts of a machinery. Okay, so there are different parts. It can be a small part which is, let's say, valued as 10 rupees, a big part which is valued as 100, a bigger part which is valued at 1,000. All these parts of a machinery has been given to the dealer, that whoever is interested to buy these parts will come to you, and you have to do what? You again have to stick to this price list given by us. And in case of any breach, what will happen? We will ask you to pay us rupees 5,000. Okay. Now, what do you think will this amount be called as? Will this be called as liquidated damages? Will this £5 will be called as liquidated damages or penalty? We have to find the distinction from these two examples. Okay. What are liquidated damages? When we say liquidated, we are basically referring to a pre-estimated damage, okay, in the contract itself. When X and Y enter into a contract, they know and they can expect that if you will sell my tire for more or a lesser amount of money, I will get a damage which can be almost close to £5. So if I am believing, or if I am putting a clause in my agreement basing it on a reasonable pre-genuine amount, so what should be the amount? The amount should be genuine, the amount should be reasonable in nature, and then you have pre-decided that amount and put it in your agreement. Okay, so that is the idea of liquidated damage. But on the other side, when we talk about penalty, the intention of the party is that in case you do not follow any of this, there is a penalty. So to enforce the contract in a much more stringent manner, the parties may decide and the parties may agree to putting a penalty clause in the agreement. So which one do you think? I am naming this as example 1 and naming this as example 2. So from your whatever you have read in your law school, whatever you have read from your Bare Act on your own or from your books, which one do you think looks more like in the nature of penalty, and which one do you think looks more of a liquidated damage? Okay, try to write your answer in the chat box and then we'll try to find out eventually whether you are right or not. So I've given you a brief introduction of what can be liquidated damages and what can be penalty. Now we have structured our lecture because we have paucity of time. We have our exams coming as well. So we have tried to structure this lecture on the basis of previous year questions. Okay. So what I'll do is I'll be teaching you these. In between, we will attempt a few MCQs, and at the end, we will also go and visit the subjective questions that have been asked. A lot of questions have now started coming from this particular provision and the concept. Okay, so please stick with me, and accordingly try to make your notes as well. Now, what is happening here? As I just explained to you, that English law also now makes a distinction between the two terms, that is liquidated damages and penalty. Okay, so this slide is basically trying to cover the concept of liquidated damages and penalty under English law. But before I get into that, I'll just tell you that this can be an expected question in your examination, wherein we say that how this concept is different in English law versus how it is there in the Indian Contract Act. That is why it is important for you to, whenever you read something where there is a difference with respect to the law that is there in Indian Contract Act and the English law, try to make your notes and try to read that particular topic very thoroughly. Okay, because they always ask you comparative question. So what is the position of liquidated damages and penalty in English law? Let's try to understand. We say there that liquidated damages and penalty are categorized as two different things in English law. Okay, right now we are talking about English law. Because it is different there, that is why it will not be allowed in every case. Now, what all cases do we allow you liquidated damages? Let's try to find out. So even though it is a term in your contract, you say this is a liquidated damage, or you say this is a penalty stipulation and we want to follow that, the court makes a distinction between the two. Okay, the court says that if it is a genuine pre-estimate of prospective damages. What is happening? If you have put a genuine estimate of the prospective damages that can happen, we will understand and we will qualify it as a liquidated damages. Does not mean that you have put the title as penalty, but the idea or intention is that of liquidated damages. Just to simply say, I have made a sale agreement, but on the top of it, I write lease deed. Now, will that change the entire or the idea of the agreement? No. So you have to, when you are reading it in its entirety, you will find out what is the intention. So if it is a genuine pre-estimate, the court will accept and the court will grant you the exact pre-genuine estimate that you have put in your agreement. Okay. So let's say if you have put the liquidated damages to be 10,000, will the court in English law allow you 10,000 per se? Yes, provided it is genuine, provided it is a reasonable amount that you have mentioned there. But if it is a highly excessive and disproportionate amount of money that you have put, what will that be called as? That will be called as penalty, and the court there will exercise their reasonability. Okay, so the court will not follow as it is what you have put in your contract. The court would rather try to see that how much amount of money is to be given or is to be paid as damages to the aggrieved party. So if in English law, if it is a liquidated damage, allow it as it is. If it is a penalty, you will indemnify the aggrieved party only to the extent of loss that has happened to them. Okay, so this is the crux that we have understood, which exists with regards to this concept in the English law jurisdiction. Now coming to section 74. And the minute we are done reading section 74, I believe you'll be able to write your answer, making a comparison between the two. So section 74 of the Indian Contract Act says compensation for breach of contract where penalty is stipulated for. Okay. Now, very important. I have told you about liquidated damages and penalty being present in section 74. You may get an MCQ as to the title of section 74. What is the title of section 74? Whether it uses the term liquidated damages, you will just simply think of my class and you will feel, okay, ma'am told us liquidated damages and I must take that both are present. No, you have to read the text from the Bare Act as well. That is why your MCQs can be based on these tricky parts. So if the title per se does not mention, you must be clear. You must write it in your Bare Act somewhere that this does not per se mention LD or liquidated damages. But it does cover liquidated damage in the provision. So let's try to read the provision now. Okay. When a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, okay, we have to divide our definition in different parts to understand it in a better manner. So first, that there is a sum named already, where in the contract as the amount to be paid in case of breach. So X and Y enter into a contract, and X has said already that if you breach, if you do not deliver the possession of the property, what will happen? You will have to pay rupees 10,000 to me, hypothetically. Okay, so what is this? A sum is named in the contract. Okay, or if the contract contains not any sum, okay, any other stipulation. It can be anything. And this is where we are going to fit one very important concept. But do you see the difference? If a sum is named in the contract versus any other stipulation by way of penalty. So penalty can be by way of a sum named, but it can also be by way of other things as well. Okay, this is the area where we have interpreted and we have come up with different concepts. So first, which one is liquidated damage now? This one is, because we have named a sum of money that in case breach happens, this amount of money will be paid. So this is liquidated damages. The second is any other stipulation which can be by way of penalty. The party complaining of the breach is entitled, and I have highlighted this very important, essential, important thing for you to remember. is entitled whether or not actual damage or loss is proved to have been caused thereby, to receive from the other party who has broken the contract reasonable compensation. Okay, now let's try to understand first part, the red part which I have written, whether or not actual damage or loss is proved to have been caused thereby. Do you remember our discussion of section 73? Therein we discussed that how do we measure damages. Ma'am, you will measure damages when you prove to the court that some loss has happened to you. Ma'am, we will measure your damages with regards to loss of profit that has happened to you. So there the prerequisite from the provision itself was found to be that some damage or loss has happened, and accordingly you are seeking compensation, which is not the case as per the reading of the provision of section 74. If you barely read the provision, it says whether or not actual damage or loss is proved to have been caused, you will still be entitled to get a compensation from the other party, provided a clause of the same exists in your contract. But there is interpretation that has been done of this. Okay, so if you get a subjective answer, I will tell you what to mention and what to write and how have we interpreted this entire concept of proving actual loss or damage or not. Okay, so from the bare provision, you have to take this part as well. So when I read my bare act, I try to find out what all different topics can be asked, what all different questions can be asked from this particular provision. This is one thing, this is second, this can be third, and this can be the fourth one. The fourth one is a reasonable compensation not exceeding the amount so named. Okay, so first thing, that if you have put rupees 10,000, can the court pay you 12,000? First question that should come to your mind. Secondly, if the damage happened only is of 8,000, will the court be bound to pay you 10,000 only? So the answer lies here. It says to receive from the party reasonable compensation which does not exceed the amount that is so named. Okay, so if I have named 10,000, can I be, if the reasonable amount is 8,000, what is that which the court will grant me, 8,000 or 10,000? Obviously it will be the reasonable amount, reasonable compensation 8,000. Can it exceed the amount that is so mentioned? Obviously not, because it very clearly says not exceeding the amount so named. So these are quick points that we have tried to understand from the bare text of section 74. And now when we move ahead and forward, we will find that what are the different case laws related to this. So I hope you've understood these four essential ingredients which I've tried to pick from section 74, and this is how we are going to grow on the concept. Okay, now before I proceed, this is one of the previous year questions. Now, if you get this question, will you be able to answer depending on the 17 minutes that you have spent with me so far? Okay, let's try to read. When a contract has been broken and a sum is named in the contract as the amount to be paid in case of breach, the amount to be paid in each case of breach, the party complaining if the breach is entitled to. The party that is complaining is entitled to what? The amount without any reference to amount of damages he has suffered, the actual amount of damage not exceeding the sum stated, the actual amount of damage if ever exceeds the sum stated, and the fourth one, reasonable compensation not exceeding the sum stated. Which one do you think is the correct answer for this? Please drop your answers. We have four options here, and if you have read the provision, the last provision that we just discussed, I believe you'll be able to find the answer of this. Okay, whether it is the actual amount of damage, whether it is the reasonable compensation, whether it can exceed the sum stated, or whether it cannot exceed the sum stated. Okay, so you can drop your answer as A, B, C, D in the chat box. All right. If you have any doubts also with regards to whatever we are discussing, you can continuously write in the chat box. We'll take up the questions at the end of the lecture. So this is the case that I discussed in the beginning. If you remember, I spoke about the manufacturer and the dealer. So the first case was Dunlop pneumatic tires, right? So this is the name of the case law that I've mentioned. And the court here said that this will not be penalty, wherein they said that you will have to pay £5 in case of each breach. This is liquidated damages. Why is it liquidated damages? Because it is a genuine amount. It looks like a genuine and a reasonable amount which the party will, the damage which the party, other party, aggrieved party will have to face in case you breach the terms of the contract. Okay. The other case that I had compared on the right side is Ford Motors versus Armstrong, where the court held that this looks more like penalty. Why is this more like penalty? Because the court here finds out that even if you breach, let's say I gave you an example, the one part was for 10 rupees, the other part was for rupees 1000 rupees. Okay. Whatever you try to sell going beyond the limit of the price list, you will have to pay how much of amount of money to the other person? 5000. So 10 or 1000, but the penalty remains same. So it looks like it is some arbitrary amount that was decided by the party, and therefore it can be categorized as penalty. Okay. I have the copy of these judgments also with me, wherein we can just refer quickly to the highlighted portion of the same. I have opened right now the judgment related to Dunlop pneumatic tires. Okay. This is a long judgment if you read. So we only will be referring to the highlighted part of the judgment. Okay. I'll just refer and show you whether they've spoken of penalty or not. Okay. So in case where the contract contains any stipulation by way of penalty, this will be a long discussion, so rather we'll take up it in the classes that we'll be doing with you. We have only few minutes left and we have a long topic to cover. So just to summarize so far, what we have discussed is the first part wherein we said that this is a case of liquidated damages. Why liquidated damages? This is a case of penalty. Why penalty? This is arbitrary. This is very genuine amount of money. This matters a lot in the English jurisdiction. These are not Indian cases per se, right? So this matters a lot in the English jurisdiction, because if it is liquidated damages, you will get your £5 which you have mentioned, no matter how much breach has happened. But if it is a penalty, the court will get into the assessment of whether the amount is reasonable or not. That is why this distinction was important. But now coming to our section 74, we just discussed that we do not make any distinction between liquidated damages and penalty. And that is what has been held by our judges in various judgments as well. So I've just mentioned the name of the case law. We'll be doing this case law with regards to other concept as well. I've just highlighted that how liquidated damages and penalty, as discussed in this particular case law, are not different from each other. So we have said here, and we have thanked our legislature, that the Indian legislature has sought to cut across the web of rules. You know, the rules that I'm telling you, if it is liquidated damages in the in other countries, you will have to go with the stated amount of money. If it is penalty, you can't go ahead with the stated amount of money. So these web of rules that are there, we have tried to let go of it. So the Indian legislature has sought to cut across the web of rules and presumptions under the English common law by enacting a uniform principle applicable to all stipulation, whether it is a stipulation by way of penalty or any other amount that is liquidated damages. So we do not have a distinction. You can expect a MCQ on this basis as well, that how are we different from English law? So both liquidated damages or penalty are considered same. This can also be one of the questions. Now, getting into the procedural aspect of how do we find out there is liquidated damages, the clause exists. If the clause exists, can the employer or can one party who's thinking that they are aggrieved, can they themselves try to take money from you, or do they have to reach to the court or not? Because, you know, let's say if X and Y have promised that in case breach happens, you will have to pay me 10,000 of rupees. Now X thinks, yes, breach has happened. Y had promised me that he will build my house by 1st of January. He has not done so. I know that there is breach that has happened. Let me ask him to give me 10,000 of rupees. Can we let the parties to do this? So that is what this discussion is about, right? Do we have to reach to the court? What is going to be the chronology for section 74 of Indian Contract Act? So it says your entitlement to claim compensation against a breach of contract will be by the opposite party is contained in both section 73 and 74. So as you go to the court in section 73, likewise you have to reach to the court in section 74 as well. Now, why did this confusion happen at the first place, ma'am? This happened because of this particular red part. There's a reason I've highlighted this in red, because this is the area of caution while reading this particular provision. It says whether, so he knows, I don't believe that, I have to prove to the court that actually 10 loss 10k is the loss that I have faced in this particular situation, because this is not required. I'm asking you to pay you 10,000. So the court has corrected and they have said that it is not going to be like that. The idea is again same, that if you feel that there has been breach of contract by delaying the performance beyond the stipulated time, you have to go to the court for the court to decide the same. Unless and until this is decided, we will not consider it as a rightful taking of amount of money. Okay. And if you do so, it will be considered and it will be classified as an unjust enrichment. You have unjustly tried to enrich yourself by taking that amount of money from the other party without first trying to find out whether the party was absolutely wrong or whether you also contributed to that particular wrong or not. Okay. Now, what has happened in this particular fact, in this particular case, let me just briefly give you the facts. This Vishal Engineers and Builders, they promised Indian Oil Corporation that we will construct. There was a construction structure that they required, and they promised that we will do this for you within a stipulated period of time. But they delayed it by 37 weeks. Okay, almost a lot of period of time. This was supposed to be delivered in April of, and it was later delivered in the next year's May. So a very big chunk amount of time which we see here, by which the delay has happened. But does that mean that Indian Oil Corporation goes to Vishal Engineers and says that you have to pay the compensation to us? No, they have to first reach to the court. The liability has to be fixed. Now, the delay in this particular case had happened because of the agitation that was happening in Uttarakhand at that point of time, because of the statehood that was, all the agitation that was going on. They felt that, the transport was affected, the labors were affected, and a lot of these situations they quoted to the court. So the court said that we have to first read, we have to first find out that who is liable and to what extent are they liable, for us to then tell you that, okay, you can go ahead and you can now approach and you can ask us to give you a remedy of the liquidated damages that you have decided in your contract. Okay. So this imposition of 10% of the contract price was considered as not right by Indian Oil Corporation. The second important point here is with regards to fixing of liability. Which one stands first, ma'am? I have, as I just said, the simple example of X and Y having a contract and a stipulation of 10,000 being there. Now, this is already there. Whether it will be 8,000, 5,000, it doesn't have to be 10,000 per se, because we have read section 74 and we have understood that it will be a reasonable amount, not exceeding the amount that is so mentioned and agreed. So it can be anything. It can be 5,000, 8,000, 12,000. The court in this particular case of BSNL versus Motorola said that fixing of liability is primary, and then comes quantification, that is secondary. So what will be the amount that will be given? That is a secondary question. Quantification is secondary. We have to first find out whether the person is actually liable for the wrongful act or not. So very important to stick to the chronology and find out, and write in your answers also that section 74 also requires the party to reach to the court and for the court to decide, court or arbitrator or anybody to decide what should be the remedy that should be given. Employers unilaterally cannot decide. Okay, so we can't say that the employers can unilaterally decide and recover liquidated damages. in this case, can Y decide that, okay, you have to pay me 10,000 of rupees? No. So this is an extension which was covered in different other cases, wherein the court said that you have to first go ahead with the primary rule. Now, in moving ahead with this, we see that in this particular case, the court held the only right which accrues with the breach is the right to sue for damages, not the right to get damages immediately, but right to sue for damages. So there is a distinction, right? As we just said in the BSNL case as well, quantification is different from fixing of liability. So you only get first the right to sue for damages, and then obviously later comes the idea of getting the compensation as well. Okay, why is all this important? Because I just told you it can be a possibility. Like we refer to the case wherein the agitation was happening. Was it only the fault of the employer? Was it only the fault of the contractor or the builder? Was it, that both the parties contributed to it? We have to refer to all these things and then accordingly find out the liability. Okay, the red part of section 74 has come now, and we have to find the answer to it. My title here says, do we need to prove actual loss in section 74? Because, ma'am, when I read the provision, it says that whether actual loss or damage is proved or not. So, what do we really follow? Now, why has this confusion happened at the first place? Let's try to understand. Okay, so I am opening a judgment in front of you for you to understand what we are basically discussing. What has happened here? Even if this is not very much visible to you, I'm reading it out, okay? So you can just understand and hear it from what I'm reading. In the case of a breach, okay, in case of a breach of some contract, it may be impossible for the court to assess compensation arising from breach. So we have classified now breach in two categories. One is where the courts can find out and assess the damages. The other is where it will be impossible for the court to find out and assess the damages. What are these cases? We will come and talk about it. There's a question also that has come recently in DJS. But there is a classification that was done in this particular case of Molla Baksh, which has been quoted in this case of ONGC versus Saw Pipes, wherein the court is taking us to that particular red part of section 74 as to whether we need to actually prove loss or damages or not. It says, in case of breach of some contracts, it may be impossible for the court to assess the compensation, while in other cases, it can be calculated in accordance with the established rules, the rules that we discussed yesterday. So, where the court is unable to assess the compensation, if the court cannot really assess the compensation, will they not grant you any compensation? Obviously, they will. And the sum named by the parties, if it be regarded as pre-genuine, may be taken into consideration as the measure of compensation. So section 74, when it says that actual loss or damage need not be proved, it is basically covering which particular type of breach? This one, the right one, wherein damages are not possible for the court to quantify or for the court to assess. Then in those cases, the court will not ask you to go through the entire process of proving the loss or damage that has happened. The court would rather do what? It will stick to the sum named by the party. The amount that you have named in your contract, we are going to grant you the same if it is regarded as a genuine pre-estimate amount. Very clearly, we have to stick to the principle of reasonability, and that is why the court will first see whether it is a genuine pre-estimate amount or not and grant you accordingly the amount which is so mentioned in the contract, because they can't really find the actual loss or damage. But in all the other cases where actual loss or damage can be realized, can be assessed by the court, in those cases the court is going to ask you, and the principle of 74 will not be any manner different from section 73. So the same way you will have to prove, sir, this much loss of profit has happened, this much of this much of loss has happened because I lost my clients also. All these special general damages will have to be proved to the court in this case as well. So that is why we have now categorized and we find out why that terminology has been mentioned and used in section 74. So we classify it in two categories, and we say that where it is impossible, we go back and we say that, okay, the stated amount, if it is genuine, we stick to that. If it is possible for you to assess, please prove to the court how much loss has happened to you, and accordingly we will grant you compensation, not exceeding the amount that you have mentioned in your agreement. So if this is getting confusing, I'll then again tell you 10,000 of loss has happened. Okay. So if the loss can be assessed, if it is possible, I will grant you the loss that has happened to you, not exceeding 10,000 of rupees, something between 0 to 10,000. Okay. So this is the second part. If we can't assess it only, then this entire discussion need not be done. We will then accordingly see and accordingly give you the compensation on the basis of this particular 10,000 that you have mentioned in your contract. Okay. Now, what are these cases wherein it gets difficult for us to actually prove loss and damages? This is one question also that has been asked in DJS. I've covered that in the last part of it, wherein the court says that how will you assess damages in case of a public contract? Okay, so I have mentioned here certain list wherein it gets really difficult and tricky for the courts to assess the damages. One is involving public contract, long-term contracts such as future, which are based on future profits, such as franchise agreements. It can be reputational damages, intangible assets. These can be certain examples by which, let's say, this ONGC was the saw pipes only. If this is something, the pipes were to be used by the public, and then you did not know how much of how much of people would have been benefited up by this particular transaction, you really cannot actually give actual loss or damage to the court. Therein, the court will stick to the amount mentioned in your agreement. So that is why the section 74 doesn't need any changes. It has been rightly codified. It's just that you have to read it in context of these judgment. ONGC was the saw pipes and Molla Baksh and other judgments that we have mentioned over here. Okay. So if there is no damage that has happened to you, can you still go and tell the court that I have 10,000 mentioned in my agreement, please give me 10,000? No. If there is no actual loss that has happened to you, but there is still infringement of right, the court may grant you nominal damages, right? And if it cannot be assessed, the court will then come and see your term of the contract and try to give you remedy. So these are different cases wherein we have covered that the court was competent to award reasonable compensation even if no actual damage is proved. When? Only and only when it cannot be proved by reasonable measures. Okay. All right. Then this also means that just something that I just covered right now, that even if there is no loss, you can go and say, I need 10,000 of rupees. No, the court will assess it on the basis of loss wherever it is possible for you to comprehend and look for the damages. Now, next is, can the stipulated amount be exceeded the actual loss? When we read section 74, we got clarity that it cannot exceed it very clearly. Section 74, in its plain meaning, it says that it cannot exceed the stipulated amount or the agreed amount. But there are two judgments that we will refer and discuss. One is this English judgment and the other is this Indian case, wherein we find that the court actually suggests that you can't exceed, you cannot exceed the stated amount of money. Okay, let me just give you the facts. This particular company enters into a agreement with the Witness Foundry Limited. They say that we will, in case of any breach that will happen, we will fulfill the performance, or we will do the performance of the contract. We will fulfill our obligation. And in case we fail in providing you with the possession of the property, you know what you can do? You can impose £20 per week on us. So this is a clause that is mentioned in the term of the contract itself, wherein they have agreed, both the parties have agreed, that in case the performance gets delayed, for every week's delay, we promise to pay you £20. Okay. Now the performance was delayed by 30 weeks. It was delayed by 30 weeks, but they actually claim for how much of compensation around. So, what should be the compensation as per this? As per the formula that they have agreed in the contractual term, 30 weeks into 20 pounds, that should be 600 pounds should be asked. But they rather ask for almost around 5859 pound. Okay. So almost 6,000 pound. You are supposed to ask for 600, but you're asking for 6,000 when you already had a stipulated amount, already an agreed amount in your contract. The court here says that we are going to stick to which one? We are going to refer and we are going to stick to this 600 pounds. Okay, so I'll just very quickly take you to the judgment so that we can discuss and we can understand and relate to it as well. Okay, not this judgment, the judgment of the Indian case law. Okay, so similar to that, we have our Indian case law as well. That is Chunnilal B. Mehta versus Century Spinning and Manufacturing Company Limited. Okay, so let's try to read it. Very similar fact again, that there was delay of performance. There was something that was already agreed. Now what happened here is that Chunnilal was, I'll just write it over here and then we discuss from the judgment. Chunnilal was appointed as a managing agent for this particular company. Okay, Century Spinning. Century Spinning promised Chunnilal something very, very promising. Okay, what is that? They said that whatever profit we are going to make, we will give you 10%. There were two clauses, so I'm writing it as clause 1, and then the next clause will be clause 2. Okay, so the first clause said that till you are in the employment of our company, we are going to give you 10% of our profit. Either this or a minimum of 6,000 of rupees. Minimum of 6,000 of rupees. Okay. And in case we terminate your contract, which we don't intend to do, but if we terminate your contract, we will pay you 6,000 per month for the leftover period of time. So let's say the contract was for 12 years. If now they terminate the contract in 6 years, okay, what should be the amount of damages that should be paid to Chunnilal? There are 6 years still left. Obviously, Chunnilal went to the court and said that I am entitled to this. This is much more than this amount of money, and I am entitled to 10% of the profit as per the agreement. The court corrected Chunnilal and said that no, you agreed to this amount of money, and that is how it will not be, we will not be exceeding this amount of money decided by both the parties, no matter whether the loss that has happened to you is more or lesser than this. Okay, so that is how we have this particular judgment, wherein the court again tries to stick to the terms of the contract and grants the compensation accordingly. So reading the highlighted part, it does not expressly or by necessary implication keep alive. So when a party goes to the court and says, sir, I don't want compensation from the agreed terms of the contract, rather something bigger, the court says this, that it does not expressly or by necessary implication keep alive the right to claim damages under general law. When you agree to a compensation, a specified compensation or penalty, you cannot say that my right to claim damages under general law is still alive. Okay. By providing for compensation in express term, the right to claim damages under general law is necessarily excluded. And therefore, in the face of it, you cannot really ask for the compensation, which is higher than the agreed amount of compensation. So these are two cases which we've read with regards to whether compensation can exceed the promised amount or the agreed amount between the two parties. Okay. Then the next topic is related to forfeiture of earnest money. Now, why forfeiture of earnest money in this entire discussion? Okay. First, you will see there have been a lot of judgments that have passed recently with regards to the discussion of this particular concept. Secondly, we have recognized and we have acknowledged now that this is also part of section 74 of Indian Contract Act. So there can be a possible question with regards to forfeiture of earnest money, and there have been questions that have asked with regards to this. Okay, so try to read this also with all diligence. Forfeiture of earnest money. So the first question that comes in my mind is that where do we fit it? A person has already paid. What is earnest money? X gets into an agreement with Y. X tells Y that X is the seller of the house. Y is the buyer of the house. Okay. X and Y agree that the buyer will first give rupees 1,000 to X as earnest money, the deposit that they are giving. Okay. And then later afterwards, he will pay the leftover amount of money of the sale price, that is 25,000. Okay. They both have contracted and they both understand that the property is being sold for 26,000. But then why has this 1,000 been paid in advance? This is earnest money, which is to give us satisfaction, to tell the other party that, listen, I have paid you this much. By this conduct of mine, you should be assured that I'm going to pay this as well, and I am interested in this transaction. Okay, so in the simplest term, if we talk about earnest money, you can consider it to be the money that you pay to the other party to ensure the other party that I am interested in this transaction and I am interested in buying this particular house. The facts that I have mentioned here is from a particular case only that we are going to cover now. So the amount of money was 24,000. So I'll keep it 24 only. So they agreed, and on 21st March, this buyer gives 1,000 rupees. On 26th March, the buyer gives 24,000 of rupees to the seller. Now, what will happen if the buyer doesn't really get to buy the property, or the seller doesn't really delivers the property? Okay, in either of the case, will the seller be entitled to keep this 1,000 of money or not? This is the discussion. Will the seller be entitled to forfeit the earnest money or not? We are not talking about this money. We are not talking about liquidated damages. We are rather talking about this particular earnest money that both the parties have agreed and put a stipulation regarding this in their contract. Before we move ahead with the case laws, I'll just take you back to section 74 again. Okay, so let's go to section 74 to find where does this fit under section 74. So we go back and we did our discussion on 74 with regards to two things. First was if a sum is named or any other stipulation. Okay. If a sum is named as the amount to be paid, can earnest money be covered here? I have named a sum 10,000 I will pay you if I do not deliver the property to you. 10,000 I will pay you or to be paid. But earnest money is something that I've already paid you and you have forfeited my earnest money. So where will that be categorized under section 74? It can be categorized under this part. Any other stipulation by way of penalty. You have forfeited my property or you have kept my earnest money. Can it be categorized here? It can be categorized here. So that is how the scope of section 74 comes into picture when we talk about forfeiture of earnest money. Okay, so this is how you read the law. Now, does earnest money fall under section 74? First question. If it falls under section 74, does it also has to pass the test of reasonability? And will the court get to decide and will they have the discretion to determine the amount of compensation or not? Okay, so these are the questions with which we try to find out whether forfeiture of earnest money can be done or not. So we move to the first case law, that is Chiranjeet versus Harswaru. Okay. Now, if we refer to this particular case law, again, the court here said there were two parties. There was a buyer, there was a seller. And in the terms of the contract itself, they had mentioned that we are going to keep your earnest money. Okay, I'll just show you the clause from the contract itself. Yeah. So later, first the person buys the property from the seller. Later, he was not able to pay the entire amount of money or to fulfill the transaction. Okay, and he writes a letter to the other person, to the buyer, and says that, okay, I will not be able to pay you the entire amount of money, and I request you to relinquish, or I request you to give back my, or restore back my earnest money that I have paid to you. Okay, so this is a letter by which the party is saying, telling the other party about his inability to pay the entire transactional amount, and he will not be in a position to actually buy the house. The High Court here, because this is a Privy Council judgment, if you see, the High Court's judgment was again reiterated, and the court said that this is absolutely fine. Okay, the purchaser must have broken the contract and he must lose his earnest money. If you see this, you will realize and you will acknowledge that the Privy Council actually acknowledged in 1925 itself that you can forfeit what? The earnest money as a way of penalty. If the earnest money has been paid to you, there can be two ways by which the earnest money can be used. I'll tell you the two ways now. The first is that the earnest money was paid to you as a part of the purchase price. Correct? When I gave you the example, I said that the amount of the land or the property is 25,000. You've paid 1,000 right now, and you'll be paying 24,000 later. So is this part of the purchase price? Yes. Can you forfeit it if I default? And will it be adjusted if I actually succeed and give you 24,000? Both are yes. Okay. If I do not really give you 24,000, you can actually forfeit my earnest money. And if I give you this 24,000, you will have to adjust this 1,000 of earnest money in the purchase price. I will not later give you 25,000. I'm giving you this as a earnest money that has to be adjusted with the purchase price later. So that is why it says earnest money is part of purchase price. When the transaction goes forward, it is forfeited. When the transaction falls through, okay, so first, if it goes forward, it becomes part of the purchase price. If it is forfeited, it will fall through, and accordingly, you will not be entitled to claim compensation or say that, okay, return my earnest money to me. Okay. Now we move to the next case law, Fateh Chand versus Balkishan. Again, a property related case wherein the seller had sold the property, the other person has bought the property, and now he has kept the earnest money of 1,000 of rupees. So the example that I told you is the fact of this particular case law. Now, when he forfeits the money, the court has said certain things, and this is a very important case which you must mention in your answer. Either you can mention it for penalty if a question not per se is asked for this, or you can mention it for forfeiture of the earnest money, because this is how it is relatable. Okay. Now we go to this particular judgment as well. So we refer to the highlighted part. The clause here said something. What is the clause in the agreement between Fateh Chand and Balkishan? It was recited in the agreement that the plaintiff agreed to sell the building together with this particular right to the land measuring this, and that 1,000 rupees were paid to him as earnest money at the execution of the agreement. So in the contract, they are very clearly mentioned that this is our earnest money that we are giving to you. Okay. Now, will you be entitled to forfeit this earnest money? Yes or no? Let's read about that. Because there was no evidence brought before the court for any loss suffered by the plaintiff in consequence of the default by the defendant, save as to the loss suffered by him in keeping out of the possession of the property. Now, the point is, why are we discussing about loss here, ma'am? You remember we just discussed section 74. Actual loss or damage has to be proved where it can be proved. Actual loss or damage will not be asked to be proved where the court cannot really assess it and it is impossible for you to prove. Now, what about earnest money? Do we have to prove actual loss here? Yes. You have to. If you want to forfeit my earnest money, you will have to convince the court and tell the court that I have kept this money of the other person, of the wrongdoing party, because I have faced certain loss. Okay. So it is very important for you that whenever you are forfeiting property, always and always you have to prove the actual loss or damage to the court. The same principle applies with this as well. Okay. The defendant had conceded that the plaintiff was entitled. Firstly, in this given set of facts, the defendant conceded also that the plaintiff, yes, is entitled to 1,000 rupees of earnest money. He was not even contesting this. Okay. But why we have read this is for us to understand that what will happen if earnest money is forfeited. Do I have to prove actual loss and damage to the other person? Yes. For me to say that this is a reasonable amount that I am forfeiting in the given situation. If the person fulfills the transaction, I cannot forfeit this earnest money. This will now become the part of purchase price itself. The plaintiff failed to prove the loss suffered by him in consequence committed by the defendant and unable to find the principal. So the court here highlights and says that we can't really find that how we should be allowing you to keep the earnest money unless and until you prove that there has been some loss that has happened to you. Okay. So section 74 covers both compensation of seeking to receive as well as amount that has already been paid. Seeking to receive is the damages for which you are reaching to the court. Liquidated damages. Already paid is the penalty that earnest money that we are talking about. Okay. Now, this is another new case law of 2024. I would request you to read this. This has come just in November, which is related to the concept of earnest money, wherein the court has again reiterated and held that you have to prove actual loss if you are interested in forfeiting of the earnest money of the other party. Okay. So, from all of this, we have now understood that there are two categories that exist under section 74. One is that of liquidated damages, the other is that of penalty. Both doesn't have any distinction when we talk about our country, when we talk about our law, because in either of the two you will have to prove what reasonable loss or actual loss or damage that has happened to you for you to claim the amount of money from the other party, no matter whether you have a already decided amount of money in your clause or not. You cannot arbitrarily be the person who's deciding it. You have to go to the court, you have to reach to the authority. They have to decide on firstly the liability, and then the question of amount of compensation arises. When we talk about the second stage of amount of compensation, the court makes two distinctions. The first one is where they can assess the damages, you will have to prove actual loss. Where they can't assess the damages, they allow you to not prove any loss, and they will now read and refer to your clause or the agreement between the parties. In addition to this, then we refer to the concept of forfeiture of earnest money, wherein we held and we understood that it can be so done, but the test of reasonability will be applicable here as well. Secondly, this earnest money cannot be arbitrarily forfeited by the other party. You will have to prove actual loss. You will have to make it part of the purchase price if the other person fulfills the obligation or the transaction or the promises that he has made in the contract. Now, before I end the class, because we've touched the time limit and we have to touch the questions also, I will just request you to refer to this particular case now. Okay. I've highlighted the paragraph. You have to go to paragraph 43. There are a lot of guidelines that the court has given. Okay. The Supreme Court has exhaustively laid down in this particular case the following words which are related to how compensation is to be assessed under section 74. So this will be a summary for you. You do not have to really read anything else. You just read this for your summary purpose. Okay. It has given you so many grounds as to what is to be done. The sum spoken, I'll just pick a few, 2, 3 out of it because we don't have so much of time. Just 2, 3 out of it for me to give you an idea that whether we have covered this or not. It says the sum spoken of may already be paid or be payable in future. Already paid is earnest money, payable in future is the liquidated damages that we are talking about, or the penalty that we are talking about. Okay. Section 74 will apply to cases of forfeiture of earnest money under a contract. So this applies to forfeiture, has been again told by the court in this case of Kailash Nath Associates. Then we take one more. Reasonable compensation will be fixed on well-known principles that are applicable to law of contract, which are to be found inter alia section 73. I told you that we have to follow what principles we discussed yesterday here as well, to go and find out the reasonable amount of compensation and damages that are to be given. But the only change that comes here is that you cannot exceed the a limit that has been decided by the parties. Okay. So if you read these guidelines, you'll be able to find out and you'll get an answer as to what all have we actually covered in today's class. Now I go to questions. Okay. The idea of discussing these questions at the end again is to give you a knowledge that what all have you covered in this 1 hour and how much beneficial is this going to be for you in attempting your answer. So we discussed one question at the beginning of the lecture. Now my second MCQ comes here. Consider the following objective of the law relating to damages. We have read section 73, we have read section 74. Now consider that what is the objective of this particular, these two provisions under Indian Contract Act. First, it is to enrich the party who has sustained loss by breach of contract. Does it actually intend to enrich the party? Secondly, punish the party who has committed the breach of contract. Do we intend to punish the person just because we had a discussion on penalty? The third, punish the party who sustained the put the party who has sustained the loss in the same position as if the contract had been performed. So you have three options. Out of it, you have to pick the best combination, whether it will be all three, 2 and 3, 3 only, 1 and 2. Okay. So drop your answer in the comment box and let me know what do you think will be the correct answer of this from what we have read. We have read section 3 and 74. We refer to the term penalty today. We have categorized liquidated and unliquidated damages. Now comes the point as to what is the objective of these two provisions. Is it to enrich the party? Is it to, take a party to a position and by enriching them? Is it to punish the party who has done the wrong? Or is it to put the party who has sustained the loss to the same position if the contract had been performed? So this is the MCQ. Now comes a very important question. See how recent it is. DGS 2022. So you can now see the importance of today's class. Now, let me just read out the question and you'll feel so happy that we have actually covered this. Proof of loss is a sine qua non for claiming liquidated damages. The red part of section 74. I hope you will remember it from me calling it the red part or the caution part. So this is the first aspect of the question, that proof of loss is a sine qua non. Do you have to prove or not? If you only read from the bare act, you may be in some confusion. But when you read the entire case laws that we have discussed today, you will be able to answer it. On proof of damages, the person complaining of breach is entitled, whether or not actual loss is proved, only reasonable compensation not exceeding the amount so named in the contract, liquidated or penalty. Explain with the help of relevant case laws, all the case laws that we discussed today, whether proof of loss, actual loss is necessary in cases of a contract of public utility projects, like construction of road project, all these things that we discussed today, the discussions that I did with you today, one person selling the property to the other, not being able to fulfill, do we have to prove actual loss or not? So if you have read with me in my class all these cases today, you will be in a very good position to attempt this particular question. Okay. Now we move to the second question. Help with the examples, the difference between damages, liquidated damages, and penalty. So now for this, you have to refer and you have to go through my other two classes if you have not, you were not present in those lectures, and you will be able to find out the answer. Liquidated damages and penalty is something we covered today. Damages is something that we covered in the last two lectures. So you will have to explain with the example that how are these different. So you can just remember the name of the case law that I've given you. You need not write the case law. You can just write down the examples or illustration on the basis of it. Or even easier, you can refer to the illustration of section 73 and 74. Good amount of illustrations that are present in both the provisions. The last question with which we conclude: A undertakes to repay B a loan of 1,000 rupees by 5 equal monthly installments, with a stipulation that in default of the payment of any installment, the whole shall become due. Okay, a lot of people have doubt with regards to this, whether this contract can be enforced, and what will you, when you start writing your answer, you see, okay, 1,000 was to be paid in 5 installments, and if the person fails, the whole becomes due. Okay, ma'am, the whole becomes due, matlab it looks like something that it is a penalty. But is it so? Do you really think that this is a penalty? You have to give your answer to me. I hope you have read the illustration of section 74, illustration F. If you refer, you will get your answer that it is not penalty. The illustration tells you why it is not, tells you that it is not penalty, but it doesn't tell you why is it not being categorized as penalty. The reason is that you have not put any additional. You don't say that if you fail, you will have to pay double the amount or 4 times of the amount. No, you say that the whole will become due on that particular date itself. So if you have paid 2 installments, rest 3 installments will also become due, and you will have to pay it on the first go. No extension of time of other monthly installments to be paid will be given to you. That is why we do not classify and we do not call it as a penalty. So with this, I conclude today's lecture. I hope you've been benefited by reading of section 73 and 74 with me. If you have any doubts, I would love to answer. If you have any doubts which you read about this particular provision and you come across those doubts later, you can ask me those about those doubts in the comment section. Okay. Thank you so much, all of you.